Guys, welcome back to Regnum Legal. My name is James Long, and today we're going to be discussing the templates that you can find on regnumlegal.com. Now, if you haven't already done so, go to regnumlegal.com and download our templates. We've got a complete estate plan package template for married persons and single persons. And it doesn't matter whether you have kids or don't have kids, they can be tailored for any kind of family situation. And I'll put the web address in the description below, or you'll also see it appear on the screen right there. So go to regnumlegal.com and then go to the resources page, and you can download either a template for married persons or templates for single persons. What we're going to discuss today is the living trust template. And what we're going to do is go through the exact process that you would go through if you want to create your own estate planning package. So I'm going to go step by step where to access the resources, how to get to the templates, and then where to click, what they look like, how to change them, and what specific edits you can make. When you're editing your own templates, they're all designed to be flexible. They're all designed to work with you and your unique estate. As we go through the tutorial today, I'll point out portions of the template that you might want to add to, or portions that you might want to delete, depending on your unique preferences. Editing and getting your living trust right is the most important thing for your estate plan. And that's why I want to spend time with you today to make sure that you can use these templates correctly. So stick with me here. It's going to be a little bit longer video. I think at the very end, you're going to come away with a living trust that will protect you, your family, and your estate, all for free. All for free. So, all I ask, please subscribe to this channel and leave your comments below so that as I go through this process, create more videos, create more tutorials, I can focus in on the types of issues that you want me to address the most. All right, thank you so much, and now let's get to the tutorial. All right, guys, welcome to the tutorial for how to access the free estate planning resources on the Regnum Legal website. There's two ways to get there. If you're coming from YouTube, you can click the direct link in the YouTube description. There's also a link to the homepage for Regnum Legal, and what you're looking at here is the homepage. Click on the Resources tab, and it'll open up. And then, of course, here's a introductory YouTube video. You've probably already seen that if you're coming here from YouTube. If not, I highly recommend checking this out because it has some important disclosures and sort of a bit of a roadmap about what this exactly is and what it's for. Got a little letter from me, a little note from me, and then here are some resources you probably should read. As I said here, if you look, recommended reading prior to using templates. The living trust templates that I use have per Stirpes distribution. You could also use per capita distribution, but you'd have to type that in yourself. So if you want to know what per Stirpes distribution is as written in the templates, this is what you're going to look at right here. All right, so then the free templates here, we got some for married persons and some for single persons. They are identical, except that in the family section, it says I am single as opposed to I am married. And the married person's trust is a joint trust. It's executed by both the husband and wife, whereas a single person's trust is just executed by one person. And here's all the different types of documents we're going to have. Right now, we only have up to here. We need to get the guardianship up, the Catholic Healthcare Directive, Orthodox Jewish Healthcare Directive, Jehovah's Witness Healthcare Directive, and the Christian Scientist Healthcare Directive. And that shouldn't say Christina Scientist, it should say Christian. Although I'm sure maybe there's someone named Christina who's a scientist, in which case maybe she wants a healthcare directive. Again, here's a nice disclosure. If your estate's over $5 million, do not use these templates. Do not use these templates. You need a specialized disclaimer trust or a specialized ABC trust with Q-tip provisions and all sorts of different things in there. Okay, again, another one, if you've got stepchildren or children from a previous marriage, don't use these templates. You can, there's nothing wrong with it. It's just I would really recommend an AB trust. All right, so if you want to use these forms, you just click I'm married, I want to design my own estate plan, or I'm single, and I want to design my own estate plan. So this time we're going to click I'm married, just because we want to go over the married couples stuff. Now, before you can access this, you need to agree to my terms and conditions. I strongly encourage you to seek proper legal counsel. You can use these forms and these templates, but you have to understand that Regnum Legal is not a law firm, and I'm not your lawyer. So you got to click that. You have to read and understand the terms, conditions, privacy policy, and disclaimers, which you can access here. You got to click that, and you understand and agree that these templates are for your own personal use, and you have to customize them yourself. You know, you can't just download them and sign them. You've got to input a few pieces of information. So you click that. You've got to click all three. Then you put your first name. Let's just use, we're going to do Jack Doe. Jack Doe is going to do this, and his email address is sure. And then you want the estate planning templates. Done, and you have access. Now you should know that Regnum Legal does not sell any of your private information to third parties. We do send out updates on estate planning documents. For example, you'll see we have these estate planning documents in the template form, but there are more templates that are coming. So as more templates get uploaded, you might get an email saying, hey, there's a new template. Also, there's going to be tutorials for all the templates. So as those tutorials get loaded up, you might get an email saying, hey, there's a new tutorial. That way you can keep up to date and you can have the most latest information. All right, so to access the templates, you just click one of these links, and we are going to start with the Married Person's Trust with Children. So we're going to start this. Now, if you are married and you don't have children, you can still use this trust. In fact, I'm going to take off with children. So the version you're going to see isn't going to say with children. It'll say just Married Person's Trust, because it's a bit of a misnomer. The template is drafted as if you have children, but it can be used for couples without children, and I'll explain that in the tutorial. So you click that, and it downloads as a Word document, and you just open it up, and you're ready to go. So that's it. That's how you use the templates. I would recommend downloading this answer sheet first. This is an estate planning answer sheet. So the very first sheet you should download is the answer sheet. It'll be a Word document. And then to do the trust, you start with a Married Person's Trust. You click on that, and it'll come up as a Word document. All right, so we're going to continue on with this tutorial, and I'll show you how to fill out the answer sheet and the Married Person's Trust. And stay tuned for that. All right, guys, thank you for being patient here. This is the estate planning answer sheet that I just discussed. It's one of the first documents you should download before you use any of the templates. And it's just a place to keep all of your information so that when the bracketed portions of the templates appear, you can refer to the sheet and remember what your prior answer was, so you can keep all the names consistent. Because in the trust templates, for example, it's just going to have a bracket that says spouse one or spouse two, and you'll want to remember, you know, what you put down for that, just so you can keep the forms consistent. Also, same thing with trust name. You're going to get to choose your own name for the trust, and you'll just see a bracket that says trust name. That means you get to edit it and get to do whatever you want with that. We're going to create a trust for a married family with 3 kids. All right, so we're going to do, if you've read my blog posts before, my typical example of the married couple is Jack and Jill. So Jack and Jill are married. They've got 3 kids, Bill, Bob, and Sue. Bill is a deadbeat, but you know, Bob's pretty responsible, so is Sue. So we'll keep that in mind when we do some estate planning. Maybe you guys have some deadbeat children as well, and you want to know how to protect your estate from deadbeat children. And we'll get on with that. All right, trust name. You can put anything you want for the trust name, literally anything you want at all. The standard, the convention is last name family trust. That's usually the convention, right? So in this case, if it's Jack Doe, it would be the Doe Family Trust. And that's it. You can also do the Doe Family Living not loving. I mean, I'm sure they're loving. Loving living trust, Doe Family Living Trust. You can also do the Doe Family Revocable Living Trust. Do that. It can be anything you want. The only thing you need is the word trust. So if you wanted it to be the ABC Trust, ABCD Trust, you can do that. And really, it's about privacy. So if you don't want your family name on the trust, you could just do initials, right? So if it's Jack and Jill Doe, you can do J and JD, J and JD Trust. And that gives you a little bit of anonymity with the trust documents. But the convention is that you see in most estate planning offices is the last name. In this case, would be Doe Family Living Trust. Yep, that's it. And we'll keep that convention, but just know that you don't have to use that if you don't want to. Spouse one, that's going to be Jack Doe. And you don't want nicknames. So sometimes Jack can be a nickname for the name John. So if Jack's name is actually John Doe, you'd put John Doe and not Jack. But in this case, it's Jack. Same thing. My name is James. I don't go by Jim or Jimmy because my dad goes by Jim. Um, and so, but if you're typically called Jim or Jimmy, you would put your proper name. In my case, it would be James. You wouldn't put a nickname like Jim or Jimmy. Put whatever name's on your driver's license because that's what the notary is going to check. All right, so Jack Doe, and he's married to Jill Doe. Jill Doe. There you go. And again, if you're single, the brackets aren't going to say spouse one or spouse two. The brackets will just say your name. So you'll just have the one name. So if Jack Doe was single, he wasn't married to Jill, maybe they're just living together and they're not actually married, and he just wants to do a single trust for himself, he'll put Jack Doe right here. But they're married, so we'll just keep it that way. And child one, again, they've got Bill Doe. He's the deadbeat. Pseudo. And Bob Doe. Don't get confused with Bob Dole, just Bob Doe. They don't have child four. All right, so you can just delete that. And you can customize it to however many children you want. If you got 10 kids, put 10 kids. Successor. This means who the successor trustee is going to be. All right, so whoever the successor trustee is, put that in there. And in our case, for reasons you're going to see, is the successor one's going to be Bob Doe, because we already said Bill is a deadbeat and we don't want Bill to have any control of the finances. So we make him not participate as a trustee. Only Bob and Sue will do it. But the beneficiaries of their estate are still going to be their kids. So they want Bill Doe, Bob Doe, and Sue Doe. In addition, they want their church. Our church is going to be Church on a Hill, because Jack and Jill went up the hill to attend Sunday service. All right, so that's how you'd fill that out. This is the estate planning answer sheet. Again, the only thing you're really going to probably struggle with is the successors, because that's going to be probably the most important decision you'll make, believe it or not. Beneficiaries, you'll probably very easily be able to pick who your beneficiaries are. It's usually going to be your kids or something like that. That's what most people want estate planning for, to make sure their estate can pass to their children. But if you want your church, or you want your friend, or you want, Habitat for Humanity, or some other charity that you support, you can always include them in the beneficiaries. But this is a sheet that you want to fill out so you have all the information in one spot. So as you come to these blank spaces in the templates, you can remember what you put down, okay? So keep that handy. And then next, what we're going to do is open up the living trust template, the married person's living trust template. It's basically the same as the single persons, so we're not going to do a separate tutorial for single persons. We'll just do the tutorial for married persons, and I'll show you how to customize it if you're single. But we'll open up that template, and we'll show you how all of this stuff gets input. All right, be patient, guys. We'll be back in just a second. Hi, guys. Thanks for joining me here. We're going to continue on with our living trust tutorial. This part of the tutorial is going to actually go over the married person's living trust template. It's the exact same as the single person's living trust template, except that it is a joint trust for two spouses. If you are looking at the single person's living trust, it's just going to say your name and it'll just have one single name. But since this is a married person's trust, it is going to say spouse one and spouse two. All right. There are only a handful of changes you need to make to this document, and all of the changes are in these brackets. So if you just, a quick way to find it is if you just go Control F and put in a bracket, you can just kind of scroll down and find everywhere where there's a bracket, and you can figure out where the changes need to be made. Okay. Um, so there's only just a very minimal amount that you need to do. Most of it's right here on this first page. And wherever you see a bracket, you're just going to check that information, check with your estate planning answer sheet, and put that information in. The name of the trust, the spouse, your name, name of your children, name of your successors, which is down here, and the name of your beneficiaries right here. Okay. All right, so let's get started. All right, so this is what the template's going to look like. And if you'll recall, and if you did it, the estate planning answer sheet, if you've done that, you'll have already sort of put all these answers down on paper. And if you'll remember, the very first thing we did was name the trust. And again, you can name it whatever you want, but we named it the Doe Family Living Trust. So we'll just put Doe Family. Family. All right. And spouse one, again, that's Jack Doe. And this is Jill Doe. All right. So you fill that in. All right. The next thing is Article 1 is all about the trust information. 90% of every edit you need to make is going to be to Article 1. And I've done that on purpose so that it sort of makes the amount of editing you have to do be more centralized and be as minimal as possible to make it as easy as possible for you. So the name of the trust is going to be known as, well, it's going to be the same. You've got it on the answer sheet and you've got it above Doe Family Trust. Title to assets. This isn't really necessary for legalities. I put it in here because I wanted you to have a place where you could remember how to title assets. And assets to any trust are titled the exact same way every single time. It's the name of the trustees and the name of the trust and the date. That's how you title it. And so what you would do is put your names down there, Jack and Jill Doe, as trustees of the, and again, it's the Doe Family Trust, Doe Family Trust, dated, and the date. The date is going to be when you are making the trust, whatever date that is. Let's just date it for today because that's the date we're doing it. It's going to be March 25th, 2020. All right, and that's it. So if you were changing title to your home, you would change title from Jack and Jill Doe as husband and wife. That's probably how they hold title now. To Jack and Jill Doe as trustees of the Doe Family Living Trust dated March 25th, 2020, and any amendments thereto. That's how title would be held, and that's how the asset gets transferred into the trust. Okay, family information. If you are married, if you're single, and if you have kids or don't have kids, this is the part where you're going to want to edit. You'll probably be doing the most editing at 1.3 right here. So family, it says we are married. If you are single, guess what? You just type I am single. Easy. All right. If you have 5 kids, easy. We have 5 living children. If you just have 1 kid, you have 1 living, not children. You just have to edit that and 1 living child. All right, but Jack and Jill, they've got 3 living children. And again, if you're married and you have no kids, we have no children, right? You would just type in no children and then delete everything else. We are married, we have no children. Done. All right. So that's why, we're not going to do a separate tutorial for families with no children or families who are single persons, etc. This is all customizable to each. All right. So we have 3 children. Their names are, and we go back to our answer sheet, and it is Bill Doe, Sue Doe, and Bob Doe. I could have just deleted that, but I didn't. There. 3 children. You've named it. All right. Now, there are some additional options down here. None of them are necessary. You can delete them if you don't want them. I put them in here because they're pretty common, and pretty common as to in terms of what most of my estate planning clients prefer. And it is a provision stating that any afterborn child, that means any child that's born after you sign this trust, is going to be treated as if they were specifically named here, right? So if Jack and Jill had another kid named Sally, right, they could amend this trust and amend this section to include all 4 of their children. They could put 4 and they can do this. But if for some reason they didn't, this section here sort of plans for that eventuality and makes it so that any child that's born to them after they sign their trust is included in the trust. It also includes adoption. So if Jack and Jill Doe have maybe they're past childbearing age, but they want to adopt a child, they can adopt a child. And if it's after the date of the trust, then their adopted child will be included in this if for some reason they forget to update it or don't amend it or die suddenly, etc. So that's sort of an important safeguard if you want it there. Disinherited children, there are, you could specifically disinherit someone. So if Jack and Jill wanted to disinherit the deadbeat Bill here, they could easily just say, you know, disinherited children, it's our intention to specifically disinherit Bill Doe. They could do that, and you could do that too if you have a specific person to disinherit. You don't have to put in any complex language to disinherit someone. You just don't include them here. So that's all that's there for. You could delete it if you don't want it. Initial trustee, you, whoever these people are, in this case, Jack and Jill. Jack and Jill's the initial trustee of the trust. And this is what I meant by successors. So the first and second successor, if we look on our answer sheet, the first successor is Bob and the second successor is Sue. The reason for that is because Bill is a deadbeat. We don't want Bill, with all his gambling debts and his alcohol addiction and all this other stuff that he's got going on, to have any role in administering this trust, because we're worried that he might use the trust assets to pay off his gambling debt, or maybe he's going to use it for his addiction. Or maybe Bill's just not good with money. Maybe he's severely in debt and can't really manage things well, and so he shouldn't be named as a trustee. As the creators of a trust, you want to pick a trustee that's reliable. Don't just throw your kid on there because he's your kid or she's your kid. Put someone who's reliable. And if your kid isn't reliable, or maybe they're too young, maybe you've got young children. I've got a 2-year-old and a 3-year-old. So I'm not going to put them as the trustees of my trust, because I don't know if, you know, if I die before they become of age, you know, I don't know if they're responsible or they will be responsible or not. I hope they're going to be productive members of society, but, you know, sometimes by the tantrums they throw, I sometimes doubt it. But nevertheless, I wouldn't put them as a successor. So really give a lot of thought into who this person should be. It's got to be someone who can understand the terms of a trust and someone you trust to carry out your wishes. So you're going to start by, we shall be succeeded by our, and then you put whoever this person is. If it's a son, a daughter, a friend, a brother, sister, girlfriend, wife, whoever, you're going to put who that successor is. In our case, it's the first successor is going to be their son, Bill, right? So we're going to be succeeded by our son, Bill Doe, right, as a first successor trustee. And then if Bill can't do it, so we put if Bill Doe is unable, unwilling, or unqualified to act, then we appoint. And again, you need to specify a relationship. The reason you specify a relationship is just so that if somebody's trying to locate this person, they could find them easier, right? A name like Bill Doe is very, very common. So if you say something like our son Bill Doe, anybody who's picking up this trust can say, okay, well, Jack and Jill had a son, his name's Bill, that's who they're referring to. But if you just put, we appoint Bill to be our successor, people can sometimes question who that is, even though maybe everyone would know it's your son. It's best if you put a relationship there. That way, if ever it's reviewed by a court, the court can be absolutely certain that that's who you meant. So in this case, the second successor trustee is going to be their daughter. They wanted Sue to be the second successor after Bill because, oh, wait, no. No. Bill's the deadbeat, right? Yeah, Bill's the deadbeat. We don't want Bill. We want Bob. Bob Doe. Oh, Bob Doe. I know that pseudo is going to be not Dudo. Pseudo is going to be the successor, the second successor. All right. There you go. Don't put deadbeats as trustees. Beneficiaries. Who are the beneficiaries? Well, you are always going to be the primary beneficiaries of the estate. After you're gone, whoever you name here is going to be the future beneficiary, meaning they don't have a right to use any of the trust assets until some future point in time. And in this case, the future point in time is your death. So the beneficiaries, again, put a relationship down so that just for identity purposes, we can figure out who this is. If you just put, hey, our beneficiary is Bill Doe, and you don't put your son, anybody named Bill Doe can come and say, no, that really meant me, and then that can cause some problems. I've never really seen that happen, but I have seen it happen where a charity was named, and two charities came out of the woodwork to figure out, and the fight was over which charity did this person mean, and the court had to review um, the history of giving of this of the person who made the trust, etc. And if you can avoid that, just be more specific. So in this case, they're going to put their children. Bill Doe, pseudo Bob Doe, right? That's their children, and they wanted their church. Our church on a hill. All right. Now, if it's a charity, again, I would probably go further, not just our church on a hill. I would probably put our church on a hill in, Placentia, California. Right. And then that narrows it down. A common example might be our church. Let's say you went to Calvary Chapel and it says, our church, Calvary Chapel. There's a lot of Calvary Chapels, but if you said our church, Calvary Chapel in Chino Hills, or our church, Calvary Chapel in Thousand Oaks, okay, well, now you know which church we're talking about here. Okay. All right, guys, and that is it. That is all the editing you really have to do until the very end of the document. The only other thing I could suggest is double click on the footer here, right? To get to the footer, I'm sure you've done this before. Go to the footer, which is this area here, and just double click the left mouse button, and it'll open up the footer. And if you want, you could put the name of the trust, the Doe Family Living Trust. And that way you've got, the Doe Family Trust in the footer of every document here. You don't have to do it for every one of them. I don't know why. Or there's a different section. There it is. All right. That way you've got the name of the trust in the footer. Again, you don't need it, but it's a nice little feature. I wanted to point out that Article 2 is the definitions. If there's a term in the trust in the template that you don't understand, go to the definitions. And I've included two types of the definition. If you look here, when necessary, I've included a simple definition followed by a more precise legal definition. And this is for two purposes. One, I want the simple definition to be easily understood by you, but I want a precise legal definition to be understood by a lawyer or a court if in the future it ever has to be reviewed by a lawyer or a court. So that's why I've done it that way. And I'll give you an example. If you go to the word issue, this is a great word because I know as a lawyer exactly what this means. And it's a shorthand legal word. If I just say my issue, that means my biological children and my adopted children. That's what issue means. It means blood children or adopted children if you make it um, mean that. So if you don't want issue to mean adopted children, you can delete it if you want. But it means your biological children. That's it. And it means that it's biological children that you had a parent child relationship with. What we want to do is prevent any kind of claim to the estate from unknown people who are claiming to be the long lost heir of your estate. And this really happens a lot in the media. You can see it happening when a celebrity dies. You might see someone come forward and say, hey, I'm the long lost daughter of Michael Jackson, and I want a chunk of the estate. Hey, I'm the son of so and so, and he had an affair with my mom 20 years ago, and I'm the son. So there's a lot of reasons why you might have a biological child out there, but not have a parent-child relationship, separate and apart from just you being a deadbeat. If you're a deadbeat who's just avoiding your children, you know, let's grow up and start taking care of our kids. But if for some reason maybe you had an affair, maybe or maybe you were young, you gave up a child for adoption, they're still your biological children, but you don't have a parent-child relationship with them. So this means that you sort of cut off those kinds of claims. But that's what issue means. That's it, this one sentence. Now, the legal definition is all of this. Leave it to the lawyers and the law to make a simple definition much more complicated. But again, if I were to put in the trust, we want to give it to our biological children and adopted children, but I didn't put issue, courts and lawyers would be confused because every single time in a will or a trust, you use the word issue. And it's so common for lawyers and judges to understand that word, even though it really makes, kind of not a whole lot of sense in layman's terms, but it just means biological children. Okay, so those are the definitions. You can go through them if you want. We're just going to kind of breeze through this, and I'll point out special provisions that maybe you want to look at. Here's the Article 3 for the trustees. This is how you appoint a trustee, how a trustee can resign, the liability of a trustee, and no bond required. If you're putting your family or a family member as the trustee, no bond is required. That's why I put no bond required, because typically people use family members. But if you're using someone like a friend or maybe a more distant relative like a cousin, I would probably put bond required, right? Just delete no and just put bond required. And the reason is because the bonds are required just in case somebody, the trustee or whoever's in charge, runs away with the money. So if you've got $1 million estate and your cousin's running the estate as the trustee and he's not required to put up a bond, he takes all the money and runs away to Mexico. Well, you could sue the person, but there's not a whole lot you can do until you catch the guy and hope he hasn't spent the money. But if a bond is required, he'd be required to post $1 million bond. And if he runs away to Mexico, the bond company gives you the money, and then the bond company goes after him to get him arrested and force him to pay the bond company. So a bond is a good idea if someone may be more distant from you, a professional trustee, a corporate trustee, or a distant relative or family friend is the trustee. You'd put no bond required, or you'd put bond required. Compensation, if you're using a professional trustee, you're probably going to want to give the trustee compensation. I've put the default in here to be there is no compensation for the trustee, usually because the default is that people making trusts want their children to be the trustee, and there's nothing wrong with that. But typically they don't want their children to be compensated. They just want the kids to be able to have the house and the whatever's left after you die. But if you want your trustee to have compensation, you can change that. All right. And we're rolling along. Okay, here's this retirement accounts. I included this in here just in case you make a mistake. And the mistake is putting your retirement account in the trust. Please don't put that in the trust. You can if you want. There's no law prohibiting it. It's just there can be some unintended consequences and some bad things that happen from a tax perspective if you put your retirement account in the trust. I put this section in here and I debated doing it, whether I should include it in the template or not, because I don't want to encourage you to put the retirement account in the trust. But I recognize that some people might, and if they do, you're going to want this in here. But just know that you probably shouldn't put your retirement account in the trust. You could put your life insurance, your bank accounts, you could put stocks in the trust, all sorts of things, just not a retirement account. And again, not for legal reasons, just the best practice is to not do that, at least in my opinion. But maybe you have a different one. Okay, trustee powers. There's going to be an attached Exhibit A. You can see here where it says there's an attached Exhibit A that details all of the trustees' powers. And that's done really to give you another layer of privacy. When you go to refinance a house that's in a trust, or buy a house that's in a trust, or sell your house when it's in a trust, you could easily do that. But what the escrow companies want is to look to see if the trustee has power to buy and sell the property. And typically the only way to do that is give them a copy of the trust. But you could also give them a certificate of trust and a copy of the trustee powers. So I've included it just as an attachable or detachable exhibit so that you don't have to give someone your entire trust if you want to do, buy property or sell property. All right, here's your retained powers. Even though you guys are becoming trustees of a trust, you retain all of these powers. And you'll see if you read through them that you basically retain the same powers you have now. So not a whole lot's going to change. All right, and finally we get to the disposition of the trust, which is in Article 6. It's the very last part of the trust. It's on around page 14 or 15. And this kind of tells you what the trust property, where it's going to go during different events. So during your lifetime, the trust property gets to be used by you exclusively. And it says here, you'll see, during our lifetime, the trustee shall pay the net income of the trust as we shall direct. So if you are still the trustee, you're going to direct yourself to pay yourself however you want. But if someone else has taken over, they have to use the property for your benefit as you direct. Now, on your incapacity, here, the trustee still has to use it for your benefit, but there are some additional rules here for what the trustee needs to be able to do. And the reason is because once you become incapacitated, the trust becomes irrevocable. Once you die or become incapacitated, the trust is no longer revocable. And now the trustee is under a different set of obligations. And those kind of are outlined here in 6.3. And then finally, if you go down to, keep going, distribution at our death. So this is what happens to your property when you die. This is the part you probably care about the most. And the first part we're going to talk about is 6.6.1 right here. And it says the trustee shall distribute free of trust such items of our tangible personal property as may be included in the trust estate in accordance with any written instructions left by us. All right, what does that mean? Well, you'll look in the forms on the website. There is a form called a tangible personal property list. I'll spell it for you. Tangible personal property list. That should be a Y. All right, tangible personal property list. And you'll see that form. You could download it. It's a one-page form. It has 2 columns. One says description and one says beneficiary. And that's where you're going to list all of your personal property and who it goes to. So if you've got specific items of personal property, for example, you might have, your wedding ring and you want it to go to your daughter, or you've got a gun collection that you want to go to your son, or you've got, some paintings that you want to go to your neighbor, or whatever you want. You write the description of the item down, who gets it, and you sign the document. And the beauty of these forms for the tangible personal property lists, you could print out as many as you like. And what this article says is that whatever written instructions you leave, your trustee has to do that first. So that's what that means. The written instructions here is talking about the tangible personal property list form on the estate planning forms. So download that tangible personal property list, and you can, as your estate goes on, as the years go on, write down, who gets what from your estate. And we're talking about personal property. You can't give away things like, your house or real property and things like that. Okay. The trustee shall divide the rest, remainder, and residue of the estate to beneficiaries. Okay, what does that mean, beneficiaries? Well, remember on our estate planning answer sheet, we listed the beneficiaries. So you just copy and paste the beneficiaries from your estate planning answer sheet, or you can go back to Article 1.5 at the very top of this document and copy and paste your beneficiaries from there, but they need to match, okay? The other thing you need to be aware of is this word here, this phrase, by right of representation. That means that the distribution is going to be per Stirpes, not per stripes. It's easy to think it's stripes. I think when I was in law school, I called it per stripes for the longest time until I realized, wait, that says per Stirpes. It's per Stirpes. And what does that mean? That means if one of your children dies, or if one of your beneficiaries die before you die, their share of the estate can still go to them by representation. That means their kids get to represent them in the distribution. So if they're supposed to get 33% of your estate, then their kids can split the deceased parent's 33%. All right. So, in other words, if you have a child who's died and they have children of their own, in other words, they leave one of your grandchildren, then your grandchildren get to split your child's share, your deceased child's share. If your child doesn't have any kids, then it gets split among your other children. So in this case here, if Sue died before Jack and Jill and she had kids, Sue's kids can get her share. But if she doesn't have kids and she dies, then the share just gets split to Bob and Bill. Okay? That's called per Stirpes. I've got a blog post about per Stirpes distribution with charts and examples and details so you can see how that works. The only other option really is, I'm going to type it in here, per capita, a capital, at each generation. Now, per capita at each generation is the only other real possibility. If you're in California, please make sure you add at each generation. Sometimes per capita can mean something different than per capita at each generation, and what you want is per capita at each generation. The general and the default is going to be per by right of representation. I think that's the most widely used and typically the most widely preferred, but you might prefer something else. So go ahead and check out my articles about per Stirpes and per capita distributions to figure out which one you like the best, and you can include it in here. I've just included by default the sort of, most widely used distribution method. All right. The other thing you got to check, if you are single or married and you have no kids, these sections talk about your children. So you're going to have to talk about different things. This envisions that you're leaving things to children. If you don't have children and you're not leaving things to children, then you're going to say each person, right? Each person's share of the trust estate shall be distributed to that person, right? So you're going to have to just replace it as necessary, and if you don't have any children, just do a find, right? You'll go find the word children and you'll figure out where it's added, and you can go ahead and change it to our beneficiaries or my brother or whoever it is as necessary. Okay, it's the trust will be the same except for the word children. Again, great grandchildren and great great grandchildren are here as well, just to show that you're intending the downline people to to inherit. Then the last part here, 6.6.3, which says when we die, if none of our children or adopted children are living and we don't have grandchildren or great grandchildren, what happens then? Well, this basically says if you have no other direct descendants, you don't have grandchildren, great grandchildren, great great grandchildren, or great 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 grandchildren, if you live that long, then it's going to go to your heirs. And who are your heirs? Your heirs, there's a whole test to figure out who your heirs are, but it's basically your brothers and your sisters, your nieces and your nephews, your cousins, your parents if they're still alive, that type of a thing. And so they basically go down and find the nearest heir, and give it to them if you don't have children, great grandchildren, or say direct lineal descendants. So that's there. But you can put any provision you want in here. If you want, if you don't have children and the people you've identified as beneficiaries are no longer existing, or the charity that you wanted your money to go to doesn't exist anymore, you can designate someone else. You can say, if we die and none of our beneficiaries are living, then we want all of our money to go to, UCLA for medical research or whatever you want. You can put whatever you want in there. This is just the catch-all. Basically, what do you want to happen to all your stuff if they can't find anybody here to give it to? What happens? And that's what would happen. All right. So next thing you're going to do is you're going to put the name of the county. They were in Orange County, so it's going to be Orange County. The date, March 25th. Let's keep that, March 25th, 2020. Doing that. You don't have to do that. Spouse 1, again, that's Jack Doe. Spouse 2, Jill Doe. The name of the trust, the Doe Family Trust. And again, you're going to sign it twice as both the settlor, which means the person who made the trust, and the trustee, which means the person who's responsible for the trust. Now, if you have a trustee who's not yourself, they're going to sign it, not you. So put whoever that is. But in 99% of the cases, the settlor and the trustee are going to be the exact same person, at least initially. All right. And that's it for the trust portion. You're going to have to fill out the notary portion, and that just requires you're going to fill out the name of the county, Orange, and whatever that means, whatever county you're from, and the name. So who is it? It's Jack Doe, and then the person is Jill Doe. So here we go. Jill Doe. All right. Don't fill in the date. Don't fill this in. And don't fill this in, okay? This the notary will fill in. The notary will fill in the date for whenever the notary notarizes it, and the notary will fill in his or her name right there. They'll handwrite it in. It'll be fine, and then they'll sign it and stamp it. You do not need to have it notarized on the same day you sign it, okay? But you do need to get it notarized at some point. So if you are sheltering in place right now, you can sign your trust. Your trust will be valid when you sign it. I include the notary in there just as another layer of protection. But as soon as you can, go to a notary and have it signed. You can call a mobile notary. They will come to your house. You can go to any post office will have notaries that can sign it. And I believe they charge between $10 and $15, I think, for each signature. So, so for example, there's 2 signatures. There's two people's signatures being notarized here. So that would be, between $20 and $30 to have that notarized. All right. All right. Exhibit A. All right. These are one of the last ones you're going to do. You're only going to need to make one change after this. Doe Family. And if you want to make it easier on yourself, just copy Doe Family. Control-C on Doe Family, because that's the next change you'll have to make. But Exhibit A is the trustee powers we discussed earlier. And this basically makes another layer of privacy protection available to you. And then if you just scroll down, keep going, the very last document at the back is Schedule A. If you'll remember at the very, very beginning in Article A, under trust property, we stated that all the property listed in Schedule A is the trust property. Well, the last change you need to make is here. You're going to Control V, Doe Family Living Trust, and as the default, I've put all household furniture and furnishings, personal effects, clothing, jewelry owned or hereafter acquired. So whatever you own that's personal to you, that's going to be in the trust. And then any and all real property we own, including our residence, put the residence you live in. Okay. And maybe it's 1, 2, 3, 4, Fake Avenue, Fake Town, Fake City. All right. But what you also need to do is list out any other property you own, right? Maybe it's 1, 2, 3, 4, another, any town street, any, yeah, fine, Antville, Wisconsin. How do you spell Wisconsin? I don't know. Antville, California, right? So any rental properties you own, any real property that you own, put it in here, specifically put it in here. And the reason is because in order for the properties to get transferred in the trust, you need to make new deeds, okay? But if for some reason you forget to make a deed, but the property is listed on this Schedule A, the court can order after your death that the property be transferred to the trust, all right? It's called a Hegstead petition, right? Hegstead petition. I'm putting it right here on the screen, Hegstead petition. And that's from a case called the Estate of Hegstead. Basically what it means is if you forget to fund the trust, but it's clear that you intended assets to be in the trust, even if you forget to fund it, the courts will still allow it to be funded after your death. So if you put the address in here, arguably even just putting any and all real property we own is sufficient, but I would put the address. Okay, and then whatever other property you've got, maybe you've got a car, right? My BMW, right, 328D. Okay, and you want the fourth thing. Maybe you've got, timeshare. My elk timeshare, right? Whatever it is, unit and whatever your wealth timeshare. And what else? What else might you own? You might have bonds. I've got savings bonds. Savings bonds. You got to have it, right? Maybe you have your checking account, number 00, whatever it is, right? And the more specific you can be, the better. So you can put Wells Fargo checking account with the checking account number. And then savings bonds, you want to do E100, blah, 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 whatever the series are, right? And you put the serial numbers down so that you can put it that the person can know. You own stocks. Maybe you own stocks. Just put, my, stocks, 100 shares of Apple, whatever it is. Now, with shares, if you really want to put it in the trust, you'll probably need to retitle your brokerage account in the name of the trust. So some of the purposes of like the real property you'll have to retitle, shares you'll have to retitle. If you've got a life insurance policy, you can put life insurance policy number for whatever it is, insurance. Oh Lord, I hope my English teacher's not reading this. Miss Padilla, if you are watching this, I am sorry. I can't spell. Okay. Now, the reason you put these things in here, like the stock, the insurance policy, and the addresses, is so that, number one, the trustee can know what you intended to include in your estate afterwards. And number two, often what happens is after you die, your beneficiaries are going to not know anything about your estate unless you are a very open person. They might not even know you have a life insurance policy, but if you put it in Schedule A, they'll know to look for it, or they'll be able to use the policy number to look it up, and so the more specific you can be, the better, right? But things like your residence, your timeshare, your stock, your life insurance policy, that's all going to have to be retitled in the name of the trust. And you can go to Article 1, I think it's Article 1.2, and that'll show you how to hold title in the name of your trust. All right, guys, that's going to be it for our tutorial of the living trust templates. We have other templates to look at, other tutorials that will be coming up, such as our healthcare directive tutorial, our power of attorney tutorial. So go ahead and check those out. So thanks a lot for paying attention, guys. Thank you for watching, and we'll see you next time. All right, guys, I hope that tutorial was simple to follow. I hope that you were able to come out of it with a trust that's good for you and good for your family. If for some reason some portion was a little bit confusing, or maybe I didn't cover a topic that you wanted me to cover in more detail, please let me know. Just leave a comment below or email me at jlong@regnumlegal.com, and I'll be sure to either email you to address your specific issue or perhaps create another tutorial video, because if you have a question, I'm sure you're not the only one, and maybe we'll need to readdress this portion of the tutorial in subsequent videos. But thanks so much for watching, guys. Please subscribe below, and we'll see you next time.